Hi, everyone. This is Gary. Welcome to this week's live to Path to Prosperity webinar. Let me just check here real quick. We'll do a quick message to you just to make sure everybody's okay on your end. So, can you see my screen and hear my voice? So, there's a message coming to you right now. If you could, each of you go ahead and just say yes, you're okay on your end. I mean, on this end, looks like we're okay. Audio visual, that's pretty good. So you should see a screen that says security deposit laws and statutes guide by state. Um, so in any case, what we're going to do tonight is we're going to go over these requirements for all 50 states. Just kidding. We're not going to do that. I just want to show you that there is a guide here you can use to determine security deposit law for your particular state. Okay, and I'm going to give you some basic guidelines based on federal law. Remember, there's federal law, then state law, then local law. And local law can pass laws as long as they don't conflict with state laws and federal. And state laws can enact laws as long as they don't conflict with federal law. And federal laws can enact laws as long as they don't conflict with God. Okay, how about that? So, in any case, I just want to go over some basics with you because some of you are working with people buying rentals, and they're going to be asking you if you can manage them. And like most agents, like I did in the beginning, I said no. But over time, I realized I should be saying yes. Okay, so I'm going to go over all the things I learned about landlord tenant law, and you can, by the way, you can actually get this. The actual law itself, the original federal statute, was a landlord tenant law of 1957, and it's been updated since then a number of times. But that's the original first set body of law about landlord tenant law. Okay, so in any case, now before we get into too much detail, just very quickly, I want to check the attendee list. Looks like most of you are on. Good. We got some veterans, some new folks. Hey, Mike, how you doing, buddy? Marianne, Lori. Hey, Jackie. Doug, good to see you, Doug. Derek, Beverly. I'm not going to go over all the names here, but welcome aboard, new and veteran agent and investor. So some of you may be in the flipping program. Some of you may be in the buying rentals program. Some of you are investor agent program students, flipping program students, managing program students, property management, that is. So tonight we're going into more in property management. That's the last webinar we did. We went into property management. We went over the screening process and all that. So tonight we're going to get into more of the actual technical stuff, nuts and bolts of deposits. You got to know this, guys, because if you accept a deposit from somebody, a whole new body of law kicks into place. It's escrow law. Okay, so before we get into all the technicalities, real quickly, just remember a few things here. We do these every week with very few exceptions. We won't be doing one of these Christmas week, um, for example, but we usually do 48 to 50 of these a year, almost every week. So if you're listening to this in recorded mode, that's great. If you listen to it live, that's even better because you can ask questions. Okay, you'll notice that by default you're in mute mode. That's by design, because we can't have 100 people with audio going at the same time. So I will call on you from time to time. I'll unmute you. In the meantime, you can use your question box to type in questions. So I'm going to go back there now just to see if anybody's actually typed in any questions. Also, well, you're going to get an email the next day, always from Beverly, that has the recording of the webinar, of course. But also, she gives you lots of updates to the systems and the platforms, training material, the schedule changes, so forth and so on. If you could always make sure you look at that email, obviously I'd appreciate it, and so would Beverly. Just keeps you current with all the happenings around here, and also events that are coming up. So we'll be plotting out the 3-day event schedule over the next few weeks. The first 2 events, 3-day events, will likely be around the greater LA region, maybe north of San Diego, somewhere between San Diego and LA for the first one. Second one will probably be just right around LA Central there. But we'll see, and we'll go on up the coast there, hit probably San Francisco and Sacramento, and after that, Seattle. After that, we probably will do one in Minneapolis, St. Paul, like early summer. Then jump the rest of the way across the country to the Northeast and start off in New England, Boston, followed by Philly, and then probably wrap up in Baltimore, Maryland. That'll be it for the 3-day events next year. That's if we do that many. We may only do 4. We're going to be discussing that in the next couple weeks here. The daily classes, January through March, probably early April, it will be all California, okay? Or January through April, excuse me, all California. So I'll be on West Coast time. That's coming up after the holidays. First class will likely be January 7th. We've already got January 8th scheduled and some other dates scheduled. But in any case, let's go ahead and get started here, guys. I hope you all had a happy Thanksgiving, by the way. If you're in America, if you're Canadian, hopefully, if you had friends who were American, you hope them have a great Thanksgiving. But we're going to jump into some material help. So before I go into the chart here, just a few things to go over, guys. And please write this down. When it comes to tenant security deposits, that's money that a tenant's going to hand over to you as a property manager as sort of an indemnity deposit in case something happens to the apartment that's their result of their actions. The reality is that money is not yours. That money actually is theirs. It belongs to the tenant who gave you the money, and you're going to be holding that money in escrow. So that body of law is called escrow law. And I'm going to go over some key points right now so you understand what's involved with escrow law. So if you're an agent or a broker and you're managing properties for people, it doesn't matter if it's 2 units. If you're managing for more than one person, you number one, you have to have a license. Except in Canada, you don't have to have a license. But number 2 is you definitely have to follow the law. So you definitely want to take notes on this, guys. Main thing again is the money is theirs. It's not yours. It's held in escrow. You're acting as a custodian for their deposit. Okay. So now beyond that, the next thing is this is how much can you collect, and what does it look like? So the reality is the chart here starts to go over some of this stuff. So for Alabama, for example, you can collect a security deposit equivalent of 1 month's rent plus reasonable amount for pet charges or pets, changes to premises, increased liability risk, so forth. Now, what I learned to do in the past, and you can write this down, this is what I did, okay? You have to check with your individual state. They're all in here. Is I collected initially 1 equivalent of 1 month's rent for the security deposit. I would also collect deposits for any pets. I would also collect a deposit for smokers, a smoker's deposit if they were smokers. And I would also collect a cleaning fee deposit. Because what I discovered early on in my investing career is people would, even if they did pay all the rent on time, at the end of if all you do is collect 1 month's rent, equivalent of 1 month's rent for security deposit, inevitably a handful of people will think at the end of the lease term, they don't have to pay you your last month's rent, you just keep the deposit. There's a couple of problems with that. Number one is most states will tell you you can't keep that security deposit and apply it towards rent unless you have a judge say you can do that. You've filed the suit, the judge says, yes, you can keep the deposit. Okay, most people don't do that. They don't even know that. They just let the tenant go, they keep the deposit, which kicks into the other problem, which is this. How well do you think they'll do cleaning your unit when they leave if they got nothing at stake? They got nothing, you've got no leverage over them. So what I did is I collect an additional amount of money for cleaning, called a cleaning deposit. So I would collect 1 month's rent. For indemnity, I would collect basically half month's rent for cleaning. I would collect whatever the pet fee was, pet deposit, if they had a pet, the smoker's deposit. There are some states where I was always able to collect 2 months' rent, first and last month's rent, because the system, the judges and all that realized that tenants would leave and not pay the last month's rent, so you could collect first and last month's rent. In those places, I would also collect the pet deposit, smoker's deposit, any other deposit I can get. In fact, I will tell you this. The name of the game is this, and you want to write this down. Before a tenant sets foot in your apartment to take possession, you want to collect as much money as you can up front. Bar none, hands down, one of the biggest lessons I ever learned is you make sure the security deposit is firmly in place and cleared, the funds have been cleared. First month's rent's also been paid and cleared. anything they give you has been paid and clear. Don't let them ever move in without paying all their deposits and all rents due for that first month. Okay. So get as much as you can get up front. Um, Now the next thing is what kind. So I just kind of went over that. So I had all kinds of policies, pet policies, smokers policies, all kinds of stuff. If they had extra cars parking on the premises, I would charge for that. I would always spin off my garages separately and have a separate lease for any garage space. Because what I found out was I could actually make more money by renting out the garages separately. Because a lot of times people, they weren't even living in one of the apartment units. They just wanted a garage to store their stuff or their car. So in any case, uh, most cases you can collect all those different types of deposits. Here's like charges for pets, charges for changes to the premises, increased liability risk. So you can come up with all kinds of deposits. It just can't conflict with local, state, or federal law. Number one. And number two is it has to be legal. If it's not, you might get away with it. But if a tenant files a complaint and you get brought up in front of a magistrate, they're going to look at that and say, well, you've charged something we don't allow, and then they'll make it, you got to pay it back, which could be a problem because the reality is in landlord tenant law, when it comes to security deposits, this is one of the biggest. The reason I spend so much time on this, guys, is it ends up being one of the most common reasons why people go to court over security deposits. The reality is at the federal level law, the law at the federal level, if you violate escrow law with a tenant security deposit, you do something wrong, in other words, they can sue you for 3 times the amount of the deposit. 3 times. That's pretty steep. Okay. So that's why we take this stuff so seriously. Um, any case, uh, let's just go through a scenario, right? You guys ready? Let's assume you've got a unit you're run. It's maybe your own unit that you own. You're managing it yourself, and someone moves out. Number one thing you want to do is do a complete walkthrough of the unit. Now, I like to do it by myself. I don't want to do it with a tenant there trying to make everything look great and all that kind of stuff. I don't want that nonsense. If they want to go through with me, I'll do that, and then I'll come back another time and do it by myself. I'll tell them that too. I'll say, I'll go through it with you, you and I together, but I'm going to go through it by myself, right? Because I don't want them trying to get me out of there fast, and it just too many things can go wrong. But while I'm there, take pictures. This is what you want to do, guys. Take pictures of every room, every common area, and including any hallways, bathrooms, kitchens, everything, the yard, the whole 9 yards. Anything that tenant had access to, you want to take pictures of, particularly damaged areas, any area where there's damage. And the reason this is important is chances are you took and you should take pictures before they moved in too. Okay. Um, so always remember that whenever you have a unit freshly remodeled or you just bought it yourself, always take a set of pictures before anybody moves in there, right? Um, and that way, whenever you have a move in, move out situation, um, you have a set of pictures as a baseline, okay? And you also have your set of pictures from when the person moved out. So, in any case, always take pictures. Hey, real quick, I'm going to check for questions here. We do have a question from Bill Morrow. Hey, Bill. Bill is asking, is it can Beverly upload the complete chart for security deposits? Yes. So let's do this. Let me go back up to the top here, Bill. The website is landlord.com. Okay, landlord.com. And the particular thing we're looking for is right here: security deposit law guide.htm. So what I'm going to do is I'm going to well, Beverly will have this. So it'll be in the email. We'll put this link in the email, Bill. That's what we'll do. Thanks for suggesting it, by the way. I was actually just thinking that. So in any case, back to this. Always take pictures. Keep a file on not just every property, but every unit in the property. And also keep a file on every tenant you've had in each unit in each property. I know it sounds like a lot of paperwork, a lot of filing, but boy, is it worth it. Okay. So in any case, On the move out, here's what happens. Let's say you find some damage. They paid all the rent, everything's good there, but they've in some way or shape or form or another damaged the unit. Obviously, you got pictures of it. You want to have the damage remedied, okay? And it costs you half of the security deposit. Let's say security deposit is $1,000, and it costs you $500 to replace a door and door frame, something like that. What you have to do is within 30 days of the tenant moving out. This is in most states. Some states it's 35 days, some states it's 45 days. But let's say it's 30 days, okay? Tenant moves out, within 30 days, you've got to return to them their deposit or any portion thereof that they are due back, less anything that you kept. If you kept any amount of it, in this case 500 in this example, you have to describe that in a written form. You have to basically write them a letter or a note, just basically written form. It's an accounting of their deposit. They gave you 1,000, you give them 500 back. You kept 500 to pay for the door replacement, and you actually have to show in most states a paid invoice. You have to show evidence that you actually did spend $500 on parts and labor replacing or repairing that door. It's very, very important that you follow that law. So let's just look at a couple of them here. I can see Alabama right away is 35 days. Let's see, Alaska, 14 to 35 days, depending on termination notice. Arizona is only 14 days. How about that? Look at Arkansas. You got 60 days. 60 days. All right, 21 days in California. In any case, you get the picture here. It varies state by state, but whatever that regulation is for your state, obviously you want to follow it. Okay. So back to this. Now, if you don't do that, if you don't follow the rules precisely, let's say you'd return half of their deposit in a handwritten note saying I had to replace the door that cost $500. They can actually go to the local magistrate and file a complaint, a landlord tenant complaint against you, because maybe they don't agree with it. And whether they do or not, the fact is they can still file a suit against you. Landlord tenant complaint is an actual lawsuit. Well, when you go in there, if you don't have your ducks in a row, if you don't have evidence, an actual paid invoice showing parts and labor that you paid to have the door replaced, the judge could say, well, I'm not going to accept that. You've got to actually give this person a remainder of the deposit. And guess what? If they filed suit for treble damages, which is 3 times the security deposit, they may actually get it. The judge might say, due to hardship and all this stuff, you prevented them from getting money they needed to put that on the next place, whatever that is. They could fine you for up to 3 times the amount of the deposit, guys. Okay, so it's extremely important that you keep that. Now, next subject is this. In most states, after a period of time, you have to accrue interest and possibly pay interest on the security deposit. In other words, let's say it's sitting in a bank account. In Pennsylvania, the rule was at the end of the second year, you had to begin accruing interest on that deposit. Okay, if they stayed that long. In some states, it's 13 months. In Virginia, I can tell you if someone is there 13 months, you've got to begin accruing interest on that. Now, here's where a lot of states differ: is do you have to pay that interest every year on the anniversary date of their move-in, or can you accrue it and pay it when they finally do leave? Well, I always interpret it as I would accrue it and pay it when they leave. The only exception was if somebody was there 5 or more years, I'm not going to wait. And I had one lady, for example, stay 27 years. Well, obviously, I'm not going to accrue all that interest for 27 years and pay her at the end. So after 5 years, I would disperse whatever interest is in there. In most cases, it's not that much. When you're talking a few dollars at best. Now, in any case, you just know this: you have to check your state law and see when is it you begin accruing interest on that security deposit, and you have to follow the rules. And I can tell you, I know people that pay interest out every single year. I don't think it's necessary. They're literally saying a check. They're spending more money on the envelope and stamp and the effort than actually the check is worth. So the other thing too is this, guys. In most states, you can also collect a percentage of the deposit to pay you for administrative purposes. Okay, um, so just know that if that kind of stuff's not in this chart, you have to actually read the landlord-tenant law, but you'll see that in there. Um, in any case, we talked about having a written statement and evidence of what you kept if you did keep anything. Um, by the way, I did mention the 5-year mark. There's something else about 5 years, and it's this. Let's say a tenant has been with you 5 years and are now into their 6th year. In some states, what they say is you can no longer raise a tenant's security deposit after 5 years. So in other words, let's say every year you've raised the rent and you increase their deposit by an equivalent amount. So your rent went from 500 to 1,000 over 5 years, and every year you raise the rent. So you could also raise the deposit by the same amount. So at the end of 5 years, you end off got $1,000 deposit on that unit from that tenant. And at that point, most states say that you can no longer increase the security deposit for that tenant after 5 years. That's what I wanted to get across to you. So in any case, does anybody have any more questions on security deposits? It's pretty serious stuff, guys. So here's one from Beverly. Hi, Beverly is asking, what if they have renter's insurance? Yeah, well, that's we're going to go over that when we get into the lease, Beverly. But I always have my tenants get renter's insurance, and actually, this is kind of important, guys. I have them name me as an additional payee. All right, so they get a renter's policy that covers their personal belongings and also provides some liability protection should one of their friends slip on the bar of soap in the bathroom in their unit and your tenant left the bar of soap on the floor. It doesn't matter. Any lawyer is going to sue them, sue you, and sue everybody else. So what happens is the first line of defense is the tenant's renter's insurance policy. Okay, it does provide some liability protection, and more importantly, it protects their personal belongings. And the reason that's important is you'll notice when you own rental properties and you buy a homeowner's insurance policy on that property, the policy will have an exclusion in there. An exclusion is that if a renter is in there, not an owner occupant, a renter, that their personal belongings are not covered with your insurance policy. That's pretty much standard. So we always make sure the tenants know that up front. We always tell them they have to have a renter's insurance policy. They have to prove it to us. They actually have to give us a copy showing me as an additional payee. Okay. And one of the reasons that's important is this. Um, you don't have to go through a bunch of hoops to get paid should something go wrong. Number one. Number two is, let's say they've been there for greater than a year and they don't renew their insurance policy. You get a notice in the mail telling you that the tenant did not renew their policy. You, as the additional payee, should be aware of it. And then you can lean on the tenant to renew their policy. So, it's Beverly, that's an excellent question. Um, let's see. This is, hey Genevieve. Hey Genevieve, I'm going to send you an email later tonight. Okay. Um, let's see. Hey Gary, FYI, it's illegal in Quebec for any deposits, but in the states or province where you can have deposits, can you keep the interest and those that have to be in the trust account? Yeah, in most cases, Genevieve, um, any interest accrued actually belongs to the tenant because the money actually is the tenant's money. It's really not our money. It's the tenant's money. So they should enjoy the benefits of any interest accrued on that account. We can keep a small portion for administrative purposes, though. Okay, that's one little caveat there. So excellent question, by the way. Thank you. Okay, this is from Pam. Hey Pam. So Pam Radio's State College, PA, and has got some rentals going on already up there. Let's see if okay, Pam, how much interest? For a while, our bank wasn't paying interest on savings accounts or on an extremely minimal amount. So good question, Pam. Um, in most cases, well, actually, in some states, I can tell you what they'll say is when you accrue interest on a deposit, it has to be at a minimum not less than 1 percentage point less than the prime rate. Okay, so if the prime rate is I'm sorry, not prime rate, um, prevailing interest rate on whatever account you're in. So let's say you're in a regular savings account. That account's been paying 1%, and the law says you can pay or you need to pay anything not less than 1% less than what the bank is paying. Then in that case, you would pay zero. In your example, the bank wasn't paying any interest at all, so you're not obligated to accrue interest on that account. Um, but the bottom line is, it generally says most states will say it'll tie it to something like prevailing, whatever the bank is paying at that time on that type of account, that goes to the tenant. Um, the bigger question is, do you have to put it in an interest-bearing account versus like a checking account, which usually is not non-interest bearing? Um, they usually don't say that. They usually don't say that. It doesn't get into that kind of language in most states and provinces. Um, but back to your question though, my rule of thumb was this: whatever the bank was paying on savings, like I always put security deposits in savings because I didn't want to. It's not something you take any risk with. I would accrue interest at that same rate. In other words, the bank does it for me. I don't have to do it. The bank does it. And then at the end of the day, when they moved out 1, 2, 3 years later, I would take my administrative fee and send in the remainder. Okay, so that's how I handled that. You would never be required to accrue interest if the type of account you're using is not accruing interest from the bank. In other words, you're not supposed to be the bank. You're just simply supposed to pass through to the tenant what the bank is paying. Excellent question. Okay, let's see. This is Jackie. Okay, Jackie's asking, what happens if the security deposit is not placed on a separate escrow account? Well, that could be trouble, Jackie. um, so, in any case, by the way, check this out. Alabama, you don't have to pay interest to a tenant. You also do not have to keep the money in a separate bank account. I'll never understand it as long as I live because in most states, because it falls in the category of escrow law, that money has to be kept in a separate account. Like look at Alaska. Um, talking about commingled funds. The reason is let's take Alabama for example. Let's say you put the deposit in your regular operations account. Okay, that could be construed as commingling funds. You're putting operating income and money, operating uh, account money in the same account as security deposit money, and the two have two different purposes. So why some states allow that is beyond me. I'm just surprised at how many don't require you to accrue or pay interest. Connecticut definitely does. Yep. Um, Washington D.C. absolutely. Yep. You got to have a separate escrow account. Um, Florida says sometimes. How about that? Let's see. Illinois says yes if you have 25 or more units. Iowa says yes after 5 years. Um, let's see. Maryland is yes, and the money has to be in a federally insured financial institution. Michigan's blank, oddly enough. Yes for Minnesota. Let's go. Let's see. Where's find Pennsylvania because that's where Pam is. Pennsylvania. Yes, if held more than 2 years. That's what I actually described that earlier. And yes, in an escrow account. Um, by the way, in Virginia, you can keep 2 months rent for 1 year, then 1 month for more. Let's go down to Virginia. In Virginia, yes, you can collect 2 months rent, security deposit, and you have to pay interest. Yes, if tenant is there more than 13 months, and it doesn't have to be in a separate account. I would tell you what, guys, as a general rule, I would always put that security deposit in a completely separate account. Okay, I would not fool around. Um, so Jackie, tell me what state you're in, Jackie. We'll go look at it. Okay. Let's see. This is Jackie. Another question from Jackie. Okay. Jackie's asking, what about if you don't renew the lease after the year and the tenant continues to live in the house without a contract on a month-to-month basis? Any problems with that? So Jackie, every state that I've been in, they actually have the law actually accounts for that scenario. It's called a holdover. A holdover tenant, they're held over longer than the term of the lease. Um, so I'll give an example of what happens in I think it's Pennsylvania. let's say you have a 1-year lease. The 1 year is up. The tenant doesn't move out, and neither the tenant nor the owner say anything about it. In that state, the lease automatically defaults to a month-to-month basis for 1 year. If another year goes by on that month-to-month basis and still nobody says anything to anybody else, that lease reverts back to its original term of 1 full year. How about them apples? Now let's say it goes into another year. Well, unfortunately, from what I remember, the statute doesn't cover that. I'm assuming it repeats. A year lease, 12-month, month to month, and it goes back to the original term of 1 year. And I'm assuming if it stays again, they stay again, it goes back to the 12 months, month to month again. But what I would do is this: if you're in a situation like that, Jackie, and you don't want the tenant there, you could give them a 30 days notice and tell them they've exceeded the term of the lease and they have to move. Or you can raise rent. You can say this is 30 days notice that we're raising the rent. There's no issue with the security deposit because you still got it. It's still in the account, I'm assuming, and they haven't moved out, so you should keep it. So there's no real issue there. Okay. In any case, good question, by the way. All right, Lori is asking about Ohio. So let's go down to Ohio and see what Ohio says. Hang on just 1 second, guys. Getting close. Ohio says, important, please read footnote below. Okay, so let's go read the footnote. So, but by the way, Lori, in Ohio, there's no stipulation on how much you can collect for deposit. Your security deposit apparently doesn't have to be, held in a separate account. The security deposit can be used for unpaid rent, damage over normal wear and tear. So let's read the footnote below and see what Ohio says. Footnote. Okay, here we go. So hang on, Lori. Ohio, any security deposit in excess of $50 or 1 month's periodic rent, whichever is greater, must bear interest on the excess at the rate of 5% per annum if the tenant remains in possession of the premises for 6 months or more. It must be computed and paid annually by the landlord to the tenant. How about them apples? So that means that's crazy. Because what if the bank you're putting the money in is not paying 5%? You need to account for that when you determine your rent rates in Ohio then. Is what it's saying in most cases, if you got more than $50 or a 1 month's rent, whichever is greater, and you must not only accrue but pay the interest, okay, annually every single year. Well, that's on $1,000 deposit. That's $50 a year. Doesn't sound like that big a deal, but you know what? If you didn't account for that when you bought the property and determine what your rental rates are going to be, that could surprise you. In fact, that surprised me. I didn't know that. So thanks for raising the question here. Let's go back here. That was Lori's question. Jackie's asking about PA. Let's go back to PA here. Hang on 1 second. I think we actually just did that, but real quick, let's just revisit it one more time just to be sure. Pennsylvania, yep. Okay, so you can collect 2 months rent for security deposit for a 1 year, okay, and 1 month, 1 month for more. I'm not sure what they mean by that, but in any case, when it comes to interest, yes, you do have to accrue interest for a tenant who's been there greater than 2 years. And yes, you do have to put that in a escrow account. No doubt about it. Okay, so let's see, that was Jackie. Okay, what about New Jersey? Okay, let's go do New Jersey. I knew we had some folks from New Jersey on here tonight. New Jersey, there we go. So if you own 10 or more units, I'm guessing what that means is, yes, you can and should collect security deposit. Yes, you do have to pay interest on it. And yes, see chart. So I'm not sure where the chart is, but that means you have to put that deposit in a separate account, okay? And this is Lori. Okay, Lori says, I just collected a $1,900 deposit I'll have to provide them the interest. Yeah, that's a pretty hefty deposit. That's kind of tough. That I've never seen a state do that, Lori. That's Lori Bowling, by the way, from Ohio. So good to see you, Lori, and you're welcome. Okay, let's do this, guys. That's pretty much it for what I want to cover in security deposit. So we'll have Beverly send this link out tomorrow. There's all kinds of things you can click on, little links for the different states. Like New York has a lot of, see local borough rent office. So there's so many different things in New York, guys, like rent control, for example. There's going to be a lot of unique little oddball things that have to be dealt with. But what I want to do now, guys, is I want to talk about the lease. This is the other big thing here. So remember the other week we talked about screening is the most important thing. Well, that's true. Getting a tenant in there, that's where the game is won or lost, is in your screening. But when it comes to the technical stuff, this is just as important. Security deposits and leases. So let's go look at a lease that I grabbed from Virginia. Okay, and I'm not going to go through all the nitty-gritty details here. I just want to point out some highlights and make some suggestions. Okay, so let's do that, and then we'll go back and check for more questions, and then we'll wrap things up after that. Right, this is an old, I call this an old school lease. I can tell by the language. I don't know if it's still current. It probably should still be current, but most leases now, the boilerplate version of them is actually follows what's called plain language laws. Okay, and the way they're written, they're much easier to understand. This has a lot of old language patterns that I can see from Old English law. But essentially, the top of the stuff up top here is obvious. You want to put the dates in of the lease, the date that you're entering into the lease, the date that the lease starts, and the date the lease ends. You want to name the location of the property, obviously. You're also going to name, also, by the way, the landlord and the tenant. Okay. So, in any case, moving down here, the term, it commences on a certain date, ends on a certain date. You can select here annual or month to month. I will tell you guys, I always do annual leases, and if I can get them to be longer, I will. Okay. In fact, one of the things I've learned to do is if I've got a really good tenant and the year's up, I'll see what I can do to enter them into a much longer term going forward. But you've got to select the term or month to month, whatever the case is. Okay, you got to name the rent. Always spell it out in plain English, and then also in a numerical figure. Now up in Quebec, it's probably going to be bilingual. I know in Toronto, a lot of them are. I would just follow. So Genevieve, I would just see in Quebec what they require there. Okay, down here we get into security deposit. We actually name, again, we spell it out, and we just spell out, and we write out in numerical form too. So we write it out in plain English, and we write it out in numerical form too. So, in any case, this talks about right here in the Virginia lease. They're obviously putting in here some language about the deposit. Usually that's in a separate form, but here they put it right in there. And by the way, you got in Virginia 45 days to return a deposit upon a move out. Okay. So use of premises in most cases is residential. This is a residential lease, by the way. So just basically for them to live there. If this was a commercial property, we would have a different lease, or industrial, or what have you. Condition of premises, assignment and subletting. I don't allow it. Most landlords don't, but you have to make sure it's spelled out. And most boilerplate leases, it is spelled out, which leads me to one quick comment here. I know a lot of people have used homegrown leases, or leases they got off the internet, or leases they got from somebody else. My recommendation is always use your board's leases, whatever board you're in, Board of Realtors it is. Use their lease. The reason is everywhere I've been, and this is true, at least from what I understand, every single state at least, is that the leases that are approved by the Board of Realtors in your state are not only meeting the plain language laws, they're also pre-approved all the way up to the state Supreme Court level. Okay, that's really, really important. And I'll give you an example. um, of what happens when you don't use the right kind of lease. This is going back probably close to 20 years ago. A famous court case. A tenant was a Section 8 tenant. The tenant was receiving a subsidy, a HUD, federal government subsidy, for the rent. They breached the lease. The landlord he filed for eviction. The landlord won at the magistrate's level. Well, the tenant went and got free legal help from neighborhood legal services, um, and appealed the judgment. So they went to the arbitrator's hearing, and the landlord won again, and the tenant appealed again to the next higher level, which is the actual um, common pleas court. Goes in front of the judge. Now get this: the lease was a Section 8 lease, a federal government lease, Section 8 lease. What the judge said though was, I'm not going to recognize that lease because it's not pre-approved in the state of Pennsylvania, is where this case was, and therefore is not doesn't have to be approved and not supported all the way up through the state Supreme Court level. And he rejected the case. This had gone on for 13 months, and the poor owner had to go all the way back to the magistrate's level and start all over again. Okay, so a famous court case. Now back to this. So hopefully now all of you will use your own board's forms. Now what this means is it doesn't mean you can't add your own language. You certainly can. So in all of my leases, I have what I call a separate addendum for rules and regulations. Okay, so uh, as long you can do that as long as the rules and regulations that you're putting in there again don't violate any local law, state law, or federal law. Right. Um, so I'll talk about that. I'll talk about that more later. Rules and regulations. In here, you can see there's our basic boilerplate paragraphs. I don't allow anybody to sublet an apartment. Um, I don't allow them to alter the rental. Excuse me. Um, Now, let's say you can't deliver possession the day before they moved in. We're supposed to move in. A big flood occurred and the apartment was damaged. Well, that talks about what happens there. Obviously, we don't want hazardous materials in our units. When it comes to utilities, uh, you know, when I buy properties, guys, I make sure I buy properties where the tenant is paying all or as many utilities as possible. I will. I may still likely pay um, the lienable items like water, the water bill, water, sewage, and garbage. The reason is it's a lienable item. If a tenant has it in their name and they move out and they haven't paid a bill, you get stuck with it. Okay, it actually stays with the property. So in any case, that's the one exception I make. Maintenance and repairs. Um, my rule is this: that when I get the unit back from a tenant, it needs to be in the same condition it was when I first leased it to them. Excluding normal wear and tear. Anything other than that, they have to pay for remodeling, right? Repairing and correcting the damages. Um, okay, inspection. You always give yourself the right uh, to inspect the property. Now, generally, in most states, you got to give them at least 24 hours notice. Some states it's 48 hours notice that you're going to come by there. The only exception if there's an emergency situation. Okay. Um, Another thing too is this. Uh, this has to do with keeping your properties rented all the time. I know I used to meet owners who I would have to train how to do this. They would wait till someone moved out, then they would go in and, you know, advertise it and show it. And it would take a month to get in the place leased again. They just lost a month's rent. And what we used to do is when a lease is coming up, if a tenant, we know the tenant's moving, we reserve ourselves the right to show the premises to any new prospective tenants, you know, during the last month of the current tenant's lease. The reason is then you can get that property under contract to lease. So the new tenant move-in date is the day after the old tenant's moving out, so you don't lose any income there. Okay. And Jackie, here's the thing that talks about holdover. See, in this lease, and I think it's in the Pennsylvania lease too, from what I remember, you can determine what happens to a holdover, a tenant holdover, right? Maybe they pay more money, maybe they pay on a daily basis, monthly basis, but this is where you put that stuff in there. It could be different than the the normal lease. You can see, or you can put any amount you want. Okay. Um, Okay, surrender of premises, animals. I actually have a separate pet deposit form and a separate addendum to the lease for pets. I actually turned pets into a profit center. I decided to have a pet policy and made more money as a result. Okay, quiet enjoyment. The tenant has the right to quiet enjoyment of the unit. Indemnification. This is the tenant indemnifying you of any liability for things that are the tenant's fault. Um, Default. Um, if the tenant defaults, the landlord must provide the tenant appropriate written notice as specified, and the tenant shall have a limited number of days to remedy the default. Um, you can have what's called a waiver of right to notice. We'll talk about that later, but in this case, the default, if the tenant defaults, this is what happens if the tenant defaults. All right, late charge. In most states, you can't charge a late fee until after the 5th day. Virginia is 3 days, right? And the late fee can't be what's called usurious, and it can't be exorbitant. It has to be reasonable, and it has to be reasonable. So in other words, if you have like a daily penalty, it it can accumulate over a month period to be greater than the actual month's rent in most cases. That's not written here. I'm just telling you that's kind of a common theme across all the states. Okay, if the tenant abandons the property, they break the lease, and you take possession back of the property. The tenant's fees, attorney's fees. Well, I think attorneys should pay their own fees. What do you think? Just kidding. uh, Basically, everybody pays their own fees. You can sue for attorney fees. You can certainly do that in a lawsuit. Um, you don't have to record the agreement, but you can record the agreement. All right. In fact, I will tell you if a tenant gets behind on the rent and you think that they're like we used to call them Philadelphia lawyers, you think that they're pretty savvy, they're getting good legal help, you might want to go ahead and record the lease. It's just like you record a deed, you can record a lease, right? Our governing law just tells you what state this is occurring in. Severability. Um, if any one provision of this agreement becomes unenforceable, the other provisions are still enforceable. This is all normal boilerplate stuff for you guys. Binding effect, descriptive headings, um, construction, that not road construction, but basically talks about gender. That's what that's talking about in singular and plural. Um, let's see, modification notice, um, and that's pretty much it. Now, here's something else I want to point out. Anybody over the age of 18 has to sign the lease. Okay, really, really important. I've had situations where um, some of them move in, and then 3 months later they get a new boyfriend, a new girlfriend, something like that, and they think it's okay for them to just start hanging out there, and they will, as long as they think it's okay. But the problem is if that other person is over the age of 18, um, and they've been there for a long enough period of time, they can claim that they can claim the right of possession because they've been there and you didn't do anything about it. So my rule of thumb is this: on the application, I always have everybody over the age of 18 put their name and social security number on the application, and I run their credit on them, and I put in there in the lease, anybody guest over 7 days have to be added to the lease with my permission. They can't just assume they can move in. The only way they can move in is if I get their application, I screen them, and I approve them for being an additional tenant on the lease. Okay, and I have the lease amended to include that new adult. Anybody over the age of 18. Really, really important. Okay, let me go back to questions here, guys, because I think I saw a few more coming in. Let's see. We got a couple of them. All right, this is from Bill. Okay, let me make sure. All right, this is from Bill. Hey, Bill. All right, I believe that in PA, if you have a multi-year lease in excess of 2 years, you may charge an additional month security deposit. This is aimed for my recollection at commercial leases. Um, yeah, that may be true, but I'm not sure. I know I always collected 2 months there because I was allowed to. Thank you very much for that. Okay, here's another question. What are top landlord-friendly states, and where could we find a list of those states for investing purposes? Um, Actually, if you go back to, and I apologize, your name is not showing up on the question, so I can't state your name, so I apologize. But let me go back here. So if you go back to this chart here, you can see and hear who the landlord-friendly states are. I can tell you as a general rule of thumb, New Jersey's not going to be one of them. Neither is New York. Believe it or not, Pennsylvania is actually more landlord-friendly than Virginia. In most cases, the southern states are going to be more landlord-friendly than the northern states. Okay, in Canada, Quebec is pretty tough on landlords. Ontario is not so bad. But if you go back up here, whoops, sorry, you can see Alabama. Um, you don't have to pay interest. You don't have to put the security deposit in a separate account. Pretty lenient. Alaska's probably a little more traditional. Like they're going to have, it's going to be more neutral. Arizona definitely going to be more like pro owner. But again, you can't just say that. So look at here. In Arizona, when someone moves out, you got 14 days to get a deposit back. That's not much time. Okay. Look at Arkansas. You got 60 days to return a deposit. You can collect 2 months rent. You don't have to pay interest. And I mean, 1 second. Let me make sure that category is right. Yeah, interest paid the tenant. You don't have to pay interest. Um, let's see. You don't have to keep the deposit in a separate account. So Arkansas will be considered a landlord-friendly state. Okay. Um, I can tell you, Florida is going to be very user-friendly. California is not going to be. California is going to be more uh, tenant-oriented and not so much owner-oriented. Let's see. Where is Florida? There's Florida. Um, Generally speaking, in Florida has one of the fastest turnarounds when it comes to evictions. You can get people out faster in Florida than any other state. Georgia is going to be pretty landlord friendly. Let's see. Texas is going to be landlord friendly. Let's go down to Texas. Uh, this is just from my recollection over all the years. So here's Texas. Look at that, right across the board. No policy on how much you can collect. Don't have to pay interest. Don't have to keep it in a separate account. Um, let's see. Any breach of lease, you can keep the deposit. That's pretty user friendly. So in any case, excellent question. Okay, this is Genevieve. Genevieve in Quebec. We have a government lease published. Okay, that's actually probably pretty good, unless the government is very um, how do I want to say this? If they're pro tenant versus pro owner, that could be. I've got a feeling from Genevieve. I know some of the folks up there, and you people still invest obviously in Quebec wherever people rent. People invest obviously, but I do know that the law up there is pretty tough on owners. One of the things that's kind of common, Genevieve, and at least in Ontario too, is in the winter months if you want to evict a tenant. Um, they won't let you evict them during the winter months. Also, if the gas or electric or heat in any way, shape, or form, if heat is discontinued during the winter months, and even though the tenant's responsible for paying it, you as the owner could be required to pay that. Okay, pretty tough stuff there. So this is Stephen. What if you have a property that is an Airbnb? Um, Airbnb, Stephen, is still relatively new. Like there's not a lot of case law on it. Um, there have been states that actually tried to ban it. I'll give you an example. Famous case, maybe last year, maybe 2 years ago, up in Manhattan, New York State, right in New York City. Um, uh, Owner was using their property as an Airbnb. There was a tenant that came in from California, San Francisco, in fact, to stay there and do some sightseeing, some shopping, and do all that kind of stuff. Well, how the local authorities found out, I have no idea how that transpired. I can't remember, but they determined that Airbnb was being leased as if it was a hotel, and yet it didn't have the right zoning and occupancy and credentials to be a hotel. It was just a single unit. they ended up not finding necessarily the owner. They actually find the tenant, the people, the renter of the Airbnb, find them $7,000. Okay, so that's kind of a weird, rare example, but um, Airbnb is unique because you're taking people's homes, whether they're single-family homes or condos or what have you, and you're renting out either the entire unit or individual rooms through Airbnb. But I will tell you, uh, there are definitely laws about that, and one of them is our occupancy laws. So if you check with your local occupancy inspector, they will tell you what the laws are in your area. They might say that if you can't have people living in your individual bedrooms who are not related over a period of like 7 days or something like that. Okay, that's pretty common. In other words, if you have people there living there in individual rooms, you're letting out rooms individually, and they're there more than 30 days, for example, that could be a problem. All right. There's specific language about that stuff. So, in any case, too new. I don't even know if we could find stuff on that. I think what's happening right now is um, it's just people are letting it ride unless somebody files a complaint, and then what they'll do is they'll look at the existing statutes and apply the existing statutes. It is interpreted. It's a subjective thing. So if a judge says, well, that doesn't look like a regular residential lease, that looks like a hotel type situation, therefore it falls under hotel motel law, that could be a real problem for an owner of a property. Now, on the other hand, if the judge says no, it looks like it's residential, we're gonna let this go. That still might not be the end of the case here. If a occupancy inspector gets wind of it, even though a judge might let it go, an occupancy inspector can request an inspection and write you up and take you back and say you're violating occupancy codes for the area. So a lot of interesting stuff there. I like Airbnb personally. I know people, a lot of my colleagues do, and we're doing pretty good with it. And by the way, thanks for the question, Stephen. Okay, this is from Pam. Pam is asking, how often do you enter the premises when you are in an eviction situation? Well, good question, Pam. I was always instructed, I've mentioned my personal attorney is named Cliff, that once an eviction process has begun, to not enter the premises at all, unless there's like an emergency situation. Okay, a tree falls on the house, there's a fire, what have you. So that's what I was told, Pam. During the eviction process, do not enter the unit unless it's something really urgent, and make sure you have somebody with you and it's documented and you're taking pictures and stuff like that. That would be my suggestion. Okay, this is from Mike. Hey, Mike, hope you're doing okay up there in New York, or down there in New York. I'm sorry, I'm actually in Canada myself. Okay, what if you, the landlord, has a tenant complaining about noise of another tenant? Is the landlord responsible to address the tenant making the noise? Well, if the tenant's yours, if both tenants are your tenants, Mike, I would say the answer is yes. Now, what I used to, and I'll address this, give you two answers here. Within that first answer, what I used to do is somebody called me up and said, the guy upstairs making too much noise. My first response is, I'm sorry to hear that. What did he say when you asked them to stop? In other words, I'm telling them, I actually write it in my rules and regulations, that on what we call nuisance calls like that they have to address it themselves personally with the other tenant before they call me. Now, I will tell you, same context here. If somebody calls the police, like let's say they don't, the guy's still noisy, they've talked to him, you've talked to him, the guy's still making noise, and the other person starts calling the police. If the police get called 3 times for the same situation within 24 hours, in most municipalities or jurisdictions, the police can actually fine you, issue you a citation to fine you for violating the noise ordinance, even though you're not the one doing it, you're the owner. Now, second scenario, let's say it's someone else's tenant. The answer is no, you're not responsible for someone else's tenant and someone else's property. Um, you could tell them you'll be glad to give them the other person's number if you have it, but I wouldn't do that. I would just stay out of it and tell them if they're not satisfied, they can call the police. And the police would step in and maybe find that other person because their tenant's not being a good tenant. So that's how I handle that. Let's see, Jackie, what are the requirements if you put up the house for sale? Yeah, you can, so Jackie, you can, even though you have a rental, you can still sell your property, even if it's occupied by a tenant. There's no reason you can't do that. Um, in fact, in your lease, in the pre-approved leases, it has language in there about if you sell the property. Now, in your lease, um, this is something to be careful of whether you're buying or selling. If your lease has language in there that says the lease survives transfer of ownership, and let's say you're buying the property, you definitely want to know that. So I make sure I read all the leases on a property before I buy the property. But the reality is you can still sell your property. You have the right to show the property, again, with 24 hours notice in most cases, sometimes 48 hours notice. So good question. You guys got some good questions tonight. Thanks, guys. Okay, this is Richard Cobb. Hey, Rich. Is there a good number, excuse me, for an annual increase in rental? But if a tenant moves out, do you go back to the original amount? Um, so, Rich, to me, rent increases have to do with market rate. So I'm not going to just raise the rent for just any good old reason. If the market rates are going up in the area for a similar type unit, I'm going to raise my rents. Absolutely. And I would tell you, you should raise your rent every year. I know a lot of owners in the past, before I coach them, they'd say, well, they're a good tenant. I don't want to lose them. I'll keep them. Well, don't raise them $100. Just raise them, $17.11 or something. Rent increases, I learned in the past, if I make it an odd figure, I almost never got questions on it. If I just put a flat $25 or $50 increase, I got pushback in some cases. But when I made it like $19.38, if they did ask a question, they would say, it seems like you just did this because increased expenses. I said, yes, that's right, increased expenses. But that's one tip you can use, Richard. Just make it an oddball amount. Um, but there's no rule of thumb. It's mainly based on the prevailing market rates for rents for similar properties. And I would never reverse things. I would never drop rates back down ever. Even in the recession, I never lowered my rates. I know people that do, but I don't do it myself. Um, okay, let's see. Texas. Oh, hey, Fassel. Yeah, I'm not sure why you're not showing up there. Um, so you're looking at something in Texas. Huh? Let's go look at Texas here. There we go, right there. Look at that. Yep, Texas, about as easy as you can get on landlords. Okay, let's see. Um, why our magistrate office said we can go in to inspect as long as we give 20. Yeah. So Pam, I'm not saying you can't inspect during an eviction process. The advice came from my attorney. He suggested that I do not go near the tenant or anywhere in a unit while I was evicting them. That was his suggestion. That the law, your lease does allow you to enter the property, right? But I'm pretty sure I wouldn't go in there just to check on things unless I had some really good reason to do it. Okay, this is who's this from? Hey Deb, how you doing? Hey Deb, how's the sale going? Hopefully it's going good. But let me know that. Shoot me a message or something. Okay, so Deb's asking. I had a friend who rented, and she found out that she was paying to heat everyone's water for other tenants. When she dug into why, her electric bill was 160 to 190 a month. Her SF was less than 600 square feet, so the electric bill was extremely high. She had various communication with owner to change the situation and then send him a letter to notice him. She was going to take a reduction in the rent due to the cost of heating everyone's water. Judge ruled she had to pay up or evict. Does this sound right? Pam, that does not sound right. If the lease said that she's paying water for all 4 units, then she should pay the heat, excuse me. But if it doesn't say that and it says she's responsible for her own gas bill, she should not have had to pay it. That judge was wrong. There's actually an act, Debbie, I think it's called it's a Utility Act, Utility Act 57, I think it was. Don't quote me on it, but I think it's Utility Act 57 that says if a tenant complains that their responsible for their own utility, gas, electric, whatever, water, and they find out that they've been paying someone else's, or someone else's light is on, kitchen light is on their electric circuit, that owner has to start paying both of their electric bills until the situation is remedied. And that is law. That's federal law. So that judge must not have known. By the way, I gotta tell you guys, most magistrates are not attorneys. They do not have law degrees. In fact, I knew one magistrate. I'm not going to name him because he's famous. Um, he used to work at the Water Authority, and he took a 3-week class on how to be a magistrate. Okay, so magistrates are not like Supreme Court judges. They're not Harvard graduates. They're, and almost, most times they're not even attorneys. Okay, so this guy, Deb, I would say that your friend should appeal and have her call the utility company. She needs to call the utility company right away, file a complaint, tell them what happened, and then they'll step in and they'll help her out. Okay, moving along. Okay, guys, that is actually it for the questions. We did get a little over the time frame tonight. I hope that's okay. Great subject. I know it's kind of an intense subject, but I also would tell you it's definitely something you want to know and learn about. So the next time we meet will be next week, which is going to be next Wednesday, the 5th, regular webinar. And what I'll do is I'll go into, let's see, what we'll do. Next week we'll talk about like pets, smokers, bookkeeping, contractors, things like that. And we'll kind of start to wrap up this whole section on property management. Also, we do have that special broadcast next Tuesday night at 8. We'll be launching the rental profits program. Again, you can use this to through the affiliate program that Beverly just rolled out to have your clients learn how to flip homes, how to buy rentals, and so forth. You get a $500. I think it's $500 or 20%. I forget what it is, but either $400 or $500 to do that. And plus, your client is now trained to work with you using the same methodologies and techniques you're being trained to use yourself. So, anyways, guys, hope you have a great night, a great rest of the week. Hope you had a happy Thanksgiving, and I look forward to seeing you next week. All right, take care and God bless. Bye-bye.